Today is Thursday. We have a justice conversation today. We want to have a conversation this time about the Communication and Multimedia Appeals Tribunal. The Communication and Multimedia Appeals Tribunal. The chairperson is Rosemary Kuria. She's with us in the studio. We want to welcome her by giving her the day's proverb.
Yes, our proverbs for the whole of this week have come from the country of Zambia. Today's bush, 5 words, is tomorrow's forest.
Today's bush is tomorrow's forest. Rosemary, good morning.
Morning to you.
Very good. Well, welcome to Kenya's biggest conversation. Make yourself comfortable. That's a hot seat. You're not in front of a tribunal.
Yeah.
You're just in front of friends.
Yeah.
Even a tribunal, I'm sure you'll tell me you're in front of friends. This proverb is from Zambia. Today's bush is tomorrow's forest. What do you think they mean by that?
Well, I guess it just means that soon the bush will grow and it will become trees and finally becomes a forest. So don't look down on the bush. It is going to become a forest. Yes.
What's the maana ya ndani?
Sorry?
What is the deeper meaning of it?
I don't know. I wish I was from Zambia. I don't know what it means in Zambia. Bushes, forests, I don't know. Yeah.
But just thinking as you do, because one of the things that is true of literally every African country, that the majority of people you find in our urban areas have a rural background.
Yes.
They came from some rural place. So when you talk bush, they're familiar with it. When you talk about forest, they're familiar with it. It's not something they're unfamiliar with.
Yeah.
So if you take your background, for instance, where I'm sure there are shrubs and bushes.
Yes.
And I'm sure
And
there are also
forests.
trees and forests.
Yes.
Just anecdotally speaking, what do you think it would mean?
I think it's precisely what I said before.
Yes.
If you see a bush, don't look down on it and think, oh, these are just shrubs. Oh, no, what's important are they? It will become tomorrow's forest. That's where the animals will be residing. So respect the bush. Yes. And do not despise the times of small beginnings. This bush is going to become a forest.
It's about the small beginnings.
Yes.
Okay. Tell us about the tribunal that you had. It's a Communications and Multimedia Appeals Tribunal.
Yes.
What does that mean?
The Communications and Multimedia Appeals Tribunal, we normally call it COMAT because it's quite a mouthful. It is established under Section 102 of the Kenya Information and Communications Act. And the purpose of the tribunal is to hear both complaints and appeals. As relates to complaints, it's complaints that may be brought against a journalist or a media enterprise. At the same time, a complaint may be brought by somebody who thinks that the right of media freedom is being impeded against a journalist or a media enterprise. On the other hand, we have appellate jurisdiction, and that is jurisdiction to hear appeals from decisions by the Communications Authority of Kenya, that is CA, and the Media Council of Kenya. So that is basically our jurisdiction.
Does it cover any other, disputes amongst entities in the multimedia space?
Only when they are escalated after a decision from the Communication Authority of Kenya, and then they come to us as an appeal.
So the first port of call would not be to you. It will be to these other entities, the
Yes.
Communications Authority and the Media Council.
Yes.
So I'm asking, because you've mentioned a lot about, the practice of journalism,
Yes.
and those appeals would land on your desk.
Yeah.
How about if one media house has a dispute with another media house?
Ordinarily,
You've infringed on our space. You have poached all our stuff. All those things.
yeah. Ordinarily, there will be disputes that will be taken to the regulator. For instance, if some regulation has been violated. So initially, the dispute will be taken to the Communication Authority, which is the regulator. If the Communication Authority of Kenya comes up with a decision, which one of the media houses is dissatisfied with, then the first port of call is to CAMAT, the Communications Authority of Kenya.
Okay.
No,
to the Communications Authority?
Or
to CAMAT directly?
To CAMAT, yes.
But there are some cases where someone can come directly to you.
Yes, but when they come directly to us, it is only strictly as a complaint.
Okay.
In fact, that's where issues of jurisdiction have been coming up, because sometimes people come to us when they should actually go to the High Court. Because what happens is that the Kenya Information and Communications Act restricts our jurisdiction. Our jurisdiction is specific, so we don't have broad jurisdiction to hear matters coming from media or ICT. It is very, very specific. So the only thing we can do is those complaints and appeals. There are people who have even come to us seeking damages. We don't have authority to order to award damages, compensation. The only thing we are allowed to do is to fine a media house, for instance, if up to 20 million if it violates some maybe the programming code or some broadcasting regulations. Yeah.
But it seems to cover only the media. But communications is broad. Telcos are communication companies.
In fact, that has been very interesting, because as far as complaints are concerned, our jurisdiction is limited, because when you look at Section 102A of KICA, that is the parent act, it appears, one of the subsections appears to imply that their complaints can come from any of the licensee of the Communications Authority. But when you get to the relief, when you go to Section 102E of the same act, when you get to the relief, it only relates to media. So, therefore, it appears that Parliament, in its wisdom, or probably lack thereof, limited complaints specifically to media issues, but gave our tribunal jurisdiction as relates to appeals on all those issues, all matters, and those we are talking about. IT companies, we are talking about media enterprises, we are talking about. What else are we talking about? We're talking about postal and courier services.
Yeah.
Yes.
And also communication companies, the ones that do walkie-talkies, radios, satellites, communication.
Yes.
Okay.
Please correct me if I'm wrong. So are we seeing that a myriad then of people could then bring complaints to the tribunal seeking some kind of redress? Or is it then just against a particular organization, in this case media and some of the others that you spoke about?
Say that again.
So somebody has a complaint against media, for example.
Yeah.
It doesn't matter who they are, they can come to the tribunal.
Yes, they can.
Okay. So now, I guess it's still linked to that. Are there then sets of then organizations who then can bring a complaint, or does it so long as it's any complaint whatsoever, it can then be brought before the tribunal?
Any complaint relating by somebody aggrieved by an action or a conduct by a journalist or a media enterprise can come to us. But the restriction is that now when it comes to the reliefs in Section 102E, there are only very, very specific things they can get from us. So and that's why I was pointing out that we can't compensate anybody. The only thing we can do is fine, ask for a retraction or an apology, maybe return of equipment that may have been confiscated. So our jurisdiction, in fact, that is perhaps what becomes the limitation with a tribunal, because a tribunal is a creature of statute.
Yeah.
So it cannot go outside the four walls of what is prescribed in the statute.
But Madam Chair, you speak about what you're able to do as though it's something minuscule and something almost insignificant. It's very significant from where I sit. I'm listening to you and I'm saying, if someone's taken my property and you can bring it back, that's a big thing.
Media equipment.
My media equipment. Yes. You can fine.
Yes.
You see, what I'm hearing is you can lay grounds for this matter to be taken to a different jurisdiction.
Yes.
Because if you say this is the case, then somebody then is armed and they can say, okay, since I wish to have a different prayer responded to,
Yes.
but this particular jurisdiction is limited in this way, I can then now take this to a different place.
Yes, and it's always important to explain to people the limits, not
Yes.
because we are complaining about our jurisdiction, but because we don't want somebody to waste their time.
To manage expectations.
Yes, so that they come to us thinking we'll award them millions because they have been defamed by SpiceFM. And yet we can't do that. The only thing we can say, apologize.
Which is where the
retract.
issue is, City. I mean, if you are going to complain, you're going to complain if you feel that you have been defamed by a certain media house. You're going to complain and you want something out of it. Not just a retraction and apology, but you also want them to feel the pinch, which is where the punishment comes in, an award. Now, she's saying that her tribunal cannot give you that award.
They
all
can,
right.
They can
actually
order.
apologize.
They can order for the media house to
okay.
retract and apologize. And then now, after having spent that whole process, you now need to go to a further step to seek that. Why not just go there straight? Why not just go to the High Court directly?
No.
And
High Court, too many cases, too long a queue. It may not necessarily work as quickly as I want. This tribunal, from what I'm hearing, the likelihood of your matter being resolved in a way that gives you at least a way forward. See, I'm seeing it as I've been told I actually have a case. Because you're being told, say sorry, it means you offended me. You're being told, pay CT Mugat 10 shillings. It means there's some damages that I'm being paid. And for me,
That's
That's a good starting point.
it's an excellent step. So if I take it to the next jurisdiction, man, I have serious grounds.
so why do people leave if they've come and they've gotten this, but they still want the 10 bob to be paid? So they have to go to the High Court or the Court
They
of
would
Appeal?
have to go to the High Court or the lower court because the lower court can award damages up to 20 million. So if somebody thinks they be contained within the lower court, then they can go there. Okay. But I think it is important to explain to people because we've had instances. I can remember a case we concluded last year, and the party you sympathized with them because you could see, you are trying to tell them that really I can see you want
Yes,
this,
you've been wronged.
Yes, but we won't be able to give you what you want. In fact, you're trying to at least so that they understand what they can or cannot get from us. Yes.
Okay, so then it comes back to that issue of those who bring a complaint.
Yes.
What is the threshold for determination of hearing of a case that comes before the tribunal? Are there certain boxes that must be filled to say, okay, we see that there's cause for 1, 2, 3, and therefore we will hear this case at the tribunal?
When we were starting off, because we are a fairly young tribunal, initially we were saying that Section 102A allows anybody to come. So at one point we entertained a case concerning a telco, communications company. But when we got to making the decision, it was very clear that probably we didn't have jurisdiction because if you hear a matter, but when you look at the raft of orders you can make, you find you can't make them, then it probably means you didn't have jurisdiction in the first place, even though the plain reading of the previous section appears to tell you that you do have power to hear the matter, but the fact that you can't give the remedies that the person wants then probably means then
You're not the right body to
you
actually
don't have
handle.
jurisdiction to hear the matter because you shouldn't. A court or a tribunal should never sit in vain. You just hear people waste people's time and then tell them.
At the end of the day, by the way, endo ongelesha CT. Wewe ndio atakusort hiyo mambo yako. After you've opened the door for them and tell them sit down, tell me all your problems. Can you imagine how frustrating that would be? But you're an appeals body. You're an appellate body.
Yes, we also an appellate.
The appellate is from the Media Complaints Commission and the Communication Authorities.
No, not Media Complaints Commission, Media Council of Kenya.
The Media Council has the Media Complaints Commission,
yes,
right?
Yes.
So if I was to complain that, I'm feeling something I have been misreported, misquoted, I've been, all those complaints that I would have against the media, I can go to the Media Council.
You can go to the Media Complaints Commission. Actually, there seems to be a parallel jurisdiction.
With yourselves.
Yes.
So the Media Complaints Commission would hear, and if I'm dissatisfied, then I can kind of appeal.
No, I think we are separate. As a matter of fact, we seem to be rivals in quotes, because if you look at the kind of remedies we can make in terms as pursuant to a complaint against a journalist or media enterprise, is like what we can give is a mirror
Of what the Complaints Commission would do.
but ours is more severe. So guess who everybody goes to? It's like us, as far as that issue is concerned, people appear to prefer the Media Complaints Commission for some reason.
Is it lack of awareness?
I don't know, but to me, I find that quite untidy, having two bodies that can hear similar issues and make parallel kind of
At the similar level.
yes, the same level. Because I believe that if somebody is dissatisfied with the finding of the Media Complaints Commission, I believe they should go to the High Court.
But
And
Madam Chair, surely, is this not democracy in operation? I mean,
You have choices.
you have choices. Go to this one or go to this one. Let me explain to you why I'm saying this. Huh? I don't know how many cases you handle in the course of a year or how many of these things are brought to your attention. If I look at just the ordinary so-called court system, judicial system, you have choices.
Yeah.
Many small cases, small issues. I mean, you're more or less spoiled for choice. But the good thing is that it's specific. If I really want, this is the matter I want to, I don't need to run to this court. I need to go to this.
Yeah.
It affords the people who need this service, should we say once again, that choice to determine where it is you would like to have your matter.
But CT,
Yes, please.
think of these courts, the Employment and Labor Relations Court or the Land and Environment Court.
Yes.
Imagine if there was a parallel court. This one is called the Employment and Labor Relations Court. Another one is called Industrial Court. That would create confusion.
Actually, I don't. Maybe this confusion I think is good. If you're calling it confusion, I see nothing wrong with this confusion. No, in all honesty, look. Let me give a simple example of why I'm thinking the way I'm thinking. Okay, if we're talking of schools in the last hour, you're talking about a primary school that's available. Okay, ideally, these primary schools are supposed to teach the same curriculum. They're supposed to provide the same preparation for that one exam that everybody sits for at the end of whichever year. Is that not so?
That's so.
Now, they are parallel, but they are complementary. I am simply saying that I'm listening to what you do and what the other complaints body does. And I'm saying they're complementary. So, yes, they may even do the same thing. But the question I'm really asking, so what? Let them do the same thing, because you now have a situation where more people have an opportunity of being heard. Instead of queuing to simply come to this delightful institution that you chair, they have the other delightful institution which somebody else chairs that they can go to. That's really all I'm saying.
Would they be doing the same thing, though,
Yeah,
Madam Chair?
they're doing the same thing. Of course, they are denying us work. So, but,
Okay.
but definitely, as you rightly say, Mr. Muga, I think, yeah.
Are they established under the same law?
No,
Because you are under KICA,
as we are under KICA, then
the
they must
Media
be under
Complaints
Media
Commission and the Media Council Act.
Act, yes.
See, CT, this is a lot of confusion, but
Chief.
Media Council Act, another one is governed by another act under the same
Yeah.
body of-
That's fine. We have private school. We have church sponsored schools. They are schools.
yeah, but they are all under the Education Act.
That's fine.
There
That's
is no
them.
Private Education Act and Public Education Act
I agree completely.
and Mission Schools Act.
I agree completely. Now, do these acts demand different things of these different institutions, or do they demand the same thing?
That's a rhetorical question.
I think he's actually looking for an answer.
I'm looking for a rhetorical response. When I look at, again here, my sentiments, I think, are biased. They're biased in this sense. Yeah? If you come from the generation that I come from, where we've seen the pursuit of justice as being something which at best was like smoke. You can see it, but every time you try to grasp it, it isn't quite available. So for us, avenues of justice can't be too much. At least in my mind, there can't be too many avenues. That's really where I come from.
Okay.
So long as the avenues exist, I say hooray. Even if there are 3 other acts and 3 other bodies, I'd still be saying hooray. Because all I'm seeing is an opportunity where people who have issues in that particular sphere have an avenue where their matters can be resolved. That's how I see it.
Maybe my issue would be
Yes.
why Kamat couldn't just have the appellate jurisdiction.
Yeah.
Then we leave the Media Complaints Commission to handle everything.
Yes.
Yes. So instead of having 2 things. Yeah.
Now, when you say that, obviously coming from desire, then have you seen that there would be some kind of discordance between those who are taking cases to this side and those who are bringing cases to the tribunal? Do you see that maybe then, you're duplicating an effort that could be merged and one just go ahead?
Absolutely. Because I think also what is likely to happen, you can even have different principles emerging from the different institutions.
Right.
So the Media Complaints Commission may take a certain position, and it may even be more manned by media people.
Yeah.
So
Right.
maybe, because one time I think somebody was trying to say that maybe we might be too strict because we sit as a court. So
But you don't have skin in the game.
yes, absolutely. So you get different approaches emerging from Kamat and from the Media Complaints Commission. So I believe it may be good, notwithstanding what my friend Muga is saying, to have a coherent approach to complaints against journalists and media enterprises.
Order is important.
Of course it is.
But that's what the Act does. It provides order.
Okay.
And then adds a this before it.
This is the Situation Room, the only way to start your day.
Conversation about the Communications and Multimedia Appeals Tribunal. The chairperson, Rosemary Kuria, is our guest today. #Justice Thursdays. Rosemary, so how many appeals or how many cases do you deal with in a year, on average?
I think I was supposed to bring those statistics, but they are not many. We don't have many. Maybe 10 or so.
Okay.
We don't have many appeals.
How many members are you?
We are,
in the tribunal?
according to the Act, we are supposed to have 7. We can have up to 7 members, but our quorum is 5 members. That's a chairperson and 4 members. The members are drawn from industry, so we have 2 members who are media experts, and then 2 members who are IT experts.
And you're not a permanent tribunal?
We are not a permanent tribunal. We have a 3-year term, renewable only once. Yes.
And you only meet to discuss cases? I mean,
Yes,
you're
we
not-
are all
You're
part-time.
not drawing an allowance for daily. You're drawing an allowance every time you
We
only-
draw sitting allowances.
Sitting allowances.
Yes. So they are based on how often that we sit.
But you must have a permanent secretariat, don't
There
you?
is a permanent secretariat. Kamat is managed by the Office of the Registrar of Tribunals. Because we are reasonably small tribunal, then it do not be useful to have a full-fledged registry for us. Yes.
So based on what we were discussing earlier before the break,
Yes.
what are the kind of cases that you've handled so far, say in the last 12, 15 months?
We've handled cases. We have had complaints, like a complaint against a media house, for instance, for publishing
In
this in a newspaper where you say so and so is no longer working for
Yes.
whoever. We've had-
Public notice.
Yes, public notice. We've had those ones. We've had appeals from decisions of CA, for instance, revoking licenses.
Okay.
And one of the things I can point out is that although we are a tribunal, we still follow the principles of the law proper, and that seems to also frustrate people. Because, for instance, if you're unhappy with a decision, okay, let me give an example. We've had a situation where the authority does not give somebody sufficient notice before, for instance, revoking a license.
Yeah.
And the position in law under the Fair Administrative Action Act is that it does not matter that the decision that the authority would have ultimately come up with that decision. If you do not follow due process.
Didn't follow due process.
Then we throw
The whole
that
thing
decision becomes overturned. So most of the appeals are relate to licensing, where people are complaining, telcos or media houses are complaining about issues of licensing, frequency, assignments, and so on. We also handled matters relating to violations of the programming code. For instance, when a media house has a program that has adult content during the watershed period of between 5 a.m. and 10 p.m. So those are some of the complaints that we have, where maybe, for instance, the authority then decides to punish, and the kind of punishment that is prescribed in the Act is fairly severe. So people, the media house will then complain that you didn't follow due process. So sometimes we don't even get to decide whether the decision was right or wrong, because maybe due process was not followed. So it is important that those processes are observed.
So what would you say are the benefits of some of these cases coming to a tribunal rather than going to court? Why would it benefit whichever party coming to a tribunal?
I think what I know so far, at least for our tribunal, is that we don't allow ourselves to get clogged by procedure. Even though we do follow procedure, we are not clogged by form. For instance, it doesn't matter how you frame your case, so long as what you are saying makes sense. We don't, if a lawyer files a matter, if you file a matter in a particular way, then a lawyer could say, strike it out because it violates all known ways of framing a matter. But we say, no, we understand what this person is complaining about, so we don't allow ourselves to get bogged down by form. And then also, our matters are not too many, so we hear them. It is faster. It is faster. Yeah. But also that informality, the fact that we'll hear you irrespective of how you present your case, is always useful.
A number of the tribunals we've had a chat with, and as is practice, then asked to wrap up their cases in 60 days. Is it the same thing here?
360 days. In
360 days?
Yes, that is the general. That's the general approach, because
like in
tribunals,
a year? Oh, okay.
Yes, but of course ourselves we conclude them much faster.
Okay.
Because we can hear from day to day if we want. We are very flexible. Yes, the 360 is it is the limit, not the target. So, and that's the general way that courts. That's the set kind of requirement. But of course, when you're coming up with your own performance measurement, you can prescribe a shorter period. But sometimes you don't want to give a shorter period, and then it affects performance measurement. But as a tribunal, we have been able to conclude matters even 4 months or much less. Yes.
There's a question that always arises in these matters, and that is, given that this is a tribunal that's supposed to provide a service for the entire country.
Yes.
How do you make this possible?
Luckily for us, we are now into virtual courts. Right now, we are sitting throughout virtually. So it means anybody can file their matter from everywhere. In fact, we've handled matters filed by advocates in Mombasa. They address us virtually. So that is not usually a problem. In fact, I can tell you we had a long-standing matter which we found when we started sitting, and the witness was testifying from the U.S. virtually. So that means distance is not a problem.
It's not a hindrance.
It's not a hindrance. Yeah.
I'm thinking of the flexibility, because if you are online, if you're virtual, as you say, then it means there really is no limit to what you can do. The only limitation might be the availability of that particular service in a jurisdiction. But then, of course, if you have a matter that you want to be heard, you'll go to a place where you can make it possible.
Yeah.
So on average, how many cases do you have, say, in a month?
We don't have many cases. That one I can tell you.
Okay.
Yeah, we don't have many cases. Like right now, we have only 2 matters pending.
All right. Now, if I want to physically come to your jurisdiction, where is it?
Where we are found. We have our offices in Forodha House, but we'll be soon be moving to Kenya Re Towers.
Okay, where's Forodha House?
Forodha House is in Gong Road. It's community, Milimani. We have Milimani High Court. Yes.
That's the place?
Yes, Forodha House.
It's called Forodha House.
Yes, there's Forodha House, but now we are moving to Kenya Reinsurance Towers. Yeah, that's in Upper Hill.
Who used to be there? KRA before?
Yes, it was KRA. No, it was not
when it was customs.
It was income tax.
Yes, that was income tax.
Income tax.
That's why the Forodha comes.
It was income tax. Yes.
Yeah.
Okay.
So you'll soon be moving now to Taifa Road, Reinsurance Plaza.
Yeah, not Kenya Re.
Kenya Re Towers.
It's in
Upper Hill.
In Upper Hill.
But you see, the beauty of a virtual court is that sometimes you don't even need a physical place, because you can call, you can email. But if you need to come physically, we are housed at the office of the Registrar of Tribunals will be housed at Kenya Insurance Towers. Yeah.
Every time I hear of a tribunal, I think of problems that require resolving.
Yes.
Okay? Let me ask, beyond coming to this show, what else has your tribunal done to ensure that people actually know about you? Advertisement, roadshow, what else?
Social media.
We have a social media presence. I think the other thing we have done, like during the Legal Service Week, we have our posters, we have our brochures, and so on. But we are aggressively moving towards this, and my appearance with you today is part of that process of creating awareness. Because I can tell you, in fact, when I shared the topic for our discussion about strengthening the links in a chain of justice, my thinking is that if you're saying, when you're talking about access to justice, if somebody does not even know that you exist, then already there's a problem.
That's justice denied. Completely.
Yes, it is denied, because or first of all, they go to Milimani commercial courts or high courts, then they are told, no, you're in the wrong forum. So if people don't know that a specific tribunal exists, and yet the law says, first of all, exhaust going to come out before you go anywhere else, then if they don't know about your existence, already you're impeding the access to justice. Yes, and so for me it has been very important, and for us as a tribunal, that we don't think of justice purely in terms of the litigation outcome. However, though we know litigation outcome is important, we should be able to give well-reasoned decisions that follow the law, but there are also the processes, intervening processes that need to be, there must be due process at every point. You talked about accessing tribunals from wherever. For instance, when you're talking about virtual court, sometimes there's a question whether can somebody, if they click on the link, are they immediately able to enter court? Those are issues relating to access to justice. If they want to follow up on their case, like you're asking where we are found physically, do they know where to find us? Because justice is not an event, it's a process. From knowing that the specific forum that will give them justice exists, right up to how they are treated when they make their inquiries. How even the judicial officer addresses them, because a judicial officer can impede access by intimidating parties and preventing them from expressing themselves. So that, to me, is an impediment to justice. So for us as a tribunal, we've been saying it is important. I think the first important thing is to ensure that people know that we exist. That is the first link in the chain, culminating in us giving good decisions, well-reasoned, credible decisions. Yeah.
Where do you draw your budget from?
Sorry?
Where do you draw your budget from?
From the Office of the Registrar of Tribunals, for the judiciary.
So your budget is part of the judiciary's budget?
Yes.
It comes then to you?
Yes.
Is it sufficient?
That's a trick question.
I think we are small, so I think it's working for now.
But in terms of all the needs that you've enumerated here, when you're preparing your budget,
yes,
you know that we need to create awareness about our existence.
Yes.
We need to, increase and improve the journey
yes,
towards people accessing us and people then coming to us and getting justice from us. I'm sure you present your budgets to the tribunal office.
Yeah, I think
do you get what you ask for?
Yes, we do. We do.
Do you ever see a case, or would you ever see cases, have you, when a case is brought before the tribunal and you have had to say you're in the wrong place, go to somewhere else?
Yes.
And why would that be?
One of them is that issue I was raising concerning where Section 102 of KICA appears to tell people who have maybe complaints against telcos that they can come to us. That's what it appears to tell them when you read it. But when we get to the relief, the remedies, none of what they want is not provided for. So then it means they're in the wrong place. So you tell them, you're not saying that, we're not even talking about the merits of your case. We're not saying that what you want from us is not legitimate, but you're just saying we are not the right forum for you to approach. So we've had those instances, and I think that's why we are saying it's important people keep knowing, and of course once you make that decision, people maybe who are trying to establish whether they can come to you, they can look at your decisions and establish whether they really should come to you or what you have decided concerning a similar matter. Then you find, like, in fact, the first case we handled, we struggled because we said we had jurisdiction because we were looking at the plain reading. But when it came to the relief, we knew we didn't have jurisdiction. So probably then going forward, anybody should be able to when they look at how we have decided that really this will be just an exercise in futility.
Rosemary,
to even start the process with us.
it sounds like you'd like something to change.
Yeah.
What would you like to change?
Widening of scope, perhaps?
Sorry?
What would you like to change? Because it sounds like you'd like something here to change.
I think
Is it that one of just saying directly that we should only be
I think
an appellate body for the other two, or we should have a wider mandate? Or what would you like?
I think what you're asking is about law reform, and that's something we'll be approaching the people the law reform, because there needs to be, for instance, that subsection that appears to say that somebody who is aggrieved by a licensee of CA, that needs to be looked into, so that you either expand the remedies or you remove this because it is misleading. Because when the person files a complaint on a matter for which there is no relief, you can't really blame them. You misled them by how you crafted that particular subsection, which, as we are saying, you are impeding the access to justice in the sense that you're preventing them from going to the right place for the first time. So they have been meandering, looking for relief here, and ultimately they will be told, we can't give you what you need. So that's an impediment to justice.
Do you think? Sorry.
No, please.
Do you think that the mandate should be broadened? Also, because we talk about that, well, you can direct for, apology, you can direct for this or the other thing. In some cases where folks are looking for a little bit more than apology, do you think that this particular tribunal should have its mandate widened a bit so you can actually say, yes, an award of such and such then ought to be determined and then given?
It could be that mandate could be widened. Of course, it will conflict with the fact that that regular courts also have jurisdiction to award compensation for defamation and other violations relating to journalism and whatnot. So that would be something that needs to be looked into, so that we decide. It is the court that decides this, but on all other things, releasing of equipment and whatever, probably the tribunal to do it.
If you were to seek to ensure that the changes you are alluding to are actually made a reality, what's the process? How does one go about tweaking these things so that they do what they're supposed to do? Because sometimes some of these things are started and stated, but until they operationalize, some of these limitations cannot actually be realized.
We've had discussions with the people at Kenya Law, and they've told us that if there's in fact, if you look at some rulings, sometimes you can see the struggle for different matters where the judge is appearing to say, I wish the law allowed me to do it. So that's a cue to escalate to the people of law reform or Kenya law reports to tell them, I think this particular section of the law is problematic. It's like the issue we are talking about, the parallel jurisdiction of CAMAT and the Media Complaints Commission. For me, that's a case for law reform to decide who specifically should handle it, so that we have consistency in the decisions, the quality, the tenure of the decisions, what they are saying about how journalists and media enterprises should conduct themselves, so that we don't have like the way he was observing that in Media Complaints Commission, those people are more invested, so maybe they handle it differently from what a court will handle it. Yes.
I think, though, when I listen to what it is that you're saying, is that even as we talk about this particular tribunal, the importance of it needs to be consumed and understood by those who are likely to require services like us.
Yes.
And it is a lot easier, since this is what we do anyway, to talk loudly and with great clarity on a subject that we know is pertinent to what we do on a daily basis. Because we are among the groups, we are among the disciplines that would actually seek services from you.
Yeah.
Okay. Now, having said that, why are you laughing? And I've not sat around to say.
Ask.
What do these services cost? Okay, I'm not going to say what I really wanted to say. And how do you determine the cost?
Before we even get to that, Mr. Muga, you have raised a pertinent question. And one of the things we were trying to do late last year was to map our stakeholders. And we had that conversation with CA. Who are the media enterprises that you have licensed? Who are the IT service providers that you have licensed? Who are the postal and courier services providers that you have licensed?
Yes.
Because then we can now find a way to engage them, and that's something that is very seriously in the pipeline. Once you map them, then you can tell them that we are here. Yes.
Well, Rosemary, I think you're doing some good work, and you're important for the work that you've been given. It's all about creating more and more publicity. And we have a platform here. Come and use it, so that in case anyone ever complains about us. Najua hii mambo ni kujuana. Rosemary Kuria is the chairperson of the Communications and Multimedia Appeals Tribunal. She's been our guest this hour on this Justice Thursday. Thank you for tuning in. Have a lovely day. We'll be back tomorrow, Friday.